Innovation is indispensable for the advancement of the society. Only when intellectual property rights are properly and completely protected can the country's economic development be improved. The international community regards the protection of intellectual property rights as an indicator for national competitiveness. Taiwan established the Intellectual Property Court on July 1, 2008. The Commercial Court was established on July 1, 2021. It was merged with the Intellectual Property Court to form the Intellectual Property and Commercial Court. The matters under the jurisdiction of the Intellectual Property Court include intellectual property civil cases, criminal cases, and administrative cases involving copyrights, trademarks, patents, unfair competition defined in the Fair Trade Act, trade secrets, plant variety rights, and plant seed rights. The Intellectual Property and Commercial Court has exclusive first instance jurisdiction over civil action. The parties should file a complaint at the Intellectual Property and Commercial Court, in which case the trial shall be presided by a single judge. When appealing, the parties shall only bring the case up to the Intellectual Property and Commercial Court of second instance jurisdiction, in which case the disputes shall be reviewed jointly by a collegial panel of 3 judges. Parties dissatisfied with the second instance civil judgment or ruling of the Intellectual Property and Commercial Court may, according to the law, appeal to the Supreme Court. First instance criminal cases of violating the Trade Secrets Act are adjudicated by the court. A party shall appeal against the judgment of first instance to the court. An appeal against the judgment of second instance rendered by the court shall be filed with the Supreme Court. First instance criminal cases of infringing trade secrets of national core key technologies under the National Security Act are adjudicated by the court. A party shall appeal against the judgment of first instance rendered by the court to the Supreme Court. Other first instance criminal cases of intellectual property are adjudicated by district courts. A party shall appeal against the judgment of first instance made by regular, summary or negotiation procedure and render district courts to the court. An appeal against the judgment in criminal cases of second instance rendered by the court shall be filed with the Supreme Court. However, juvenile criminal cases shall be processed by a juvenile court or juvenile division. Persons who dissatisfied with the administrative actions made by the Intellectual Property Office, Appeal Board or other government agencies may file a suit to the Intellectual Property and Commercial Court. Parties may, according to the law, appeal to the Supreme Administrative Court should they are not satisfied with the judgment of an administrative litigation case made by the Intellectual Property and Commercial Court. In order to advance the efficiency and professionalism of trials, the intellectual property litigation system has the following features. Before have been reassigned to the position, the candidate judges of the Intellectual Property Court must attend pre-employment training and must continue on-the-job studies each year in order to increase the capacity for handling different types of intellectual property cases. Since intellectual property cases often involve technical expertise in different disciplines, technical examination officers are assigned in accordance with the subject techniques involved in each of the subject case to help adjudicate technical issues. The expert witness system is adopted, and parties may ask an expert witness to provide professional opinions. In cases of infringement of patent rights, software copyright, and trade secrets, the court may appoint a neutral technical expert to serve as the investigator and execute the process of evidence collection. In order to increase the efficiency in the adjudication of intellectual property civil cases, the court shall discuss and formulate a trial plan with both parties. In order to quickly resolve intellectual property disputes once in a single proceeding, the court has the authority to decide whether there are reasons to cancel or revocate the disputed intellectual property rights in a civil or criminal intellectual property case without staying the trial proceedings. When the infringer argues the validity of a patent, the patent right holder may correct the patent claim as a redefense against the defense of invalidation. The court shall have the discretion to determine the legality of such correction. For the sake of improving trial proceeding and protection of trade secret, the Intellectual Property and Commercial Court provides the mechanism of the issuance of confidentiality preservation order. Persons who are included in a confidentiality preservation order bear the duty of confidentiality and will be subject to criminal liability should they violate the order. Intellectual Property and Commercial Court is the court first to provide e-filing system on July 20, 2015, via which parties may electronically file complaints, petition, and appeal, transmit and receive litigation documents online. Intellectual Property and Commercial Court provides modern technological equipment and has also digitalized all case files for involved parties to use during trial proceedings. Trial can also be conducted by using video conferencing system. Even court statements and digitalized files can be displayed simultaneously as well. The authenticated copy of judgments may be served in electronic form. Intellectual property is the fruits of human innovation. Taiwan provides sound and accountable legal systems to protect all kinds of intellectual property rights, the fruits of the innovation created by the authors and inventors. In the future, Intellectual Property and Commercial Court will continue to create a robust and practical foundation in order to improve the quality of judgments. Intellectual Property and Commercial Court will also continue to communicate with domestic and foreign peers and digest academic theories and insights in order to align with international professional standards, optimize the business environment in Taiwan, and enhance national competitiveness